judges in. My name is Georgia Vlahos, and I'm co-president of the Evanston League of Women Voters. We are pleased to welcome members of the Cook County League, as well as several other local leagues who have joined us this evening for this informative discussion. If you have questions of our panel, please put them in the chat. As mentioned earlier, we're recording this session, and a link to the video will be available on our website at lwve.org. We're very pleased to introduce our moderator for this evening, Larry Suffredin. Most of us know Larry as our Cook County Commissioner from 2002 to 2022. Among his many accomplishments as a commissioner, many of us are especially appreciative of his commitment to our forest preserves. But he is a practicing attorney, and he has been in private law practice from 1975 to the present. Among his varied law career accomplishments, he's argued before the Illinois and United States Supreme Courts, as well as the U.S. Court of Appeals and the Illinois Appellate Court. Welcome, Larry. We'll let you introduce our distinguished guests.
Thank you, Georgia. I appreciate the League being interested in this. The judiciary is more in the news in the last few months than it has been in a long time. The judges that are primarily being discussed are United States District Court judges, the Court of Appeals, and the United States Supreme Court. So before I introduce our panelists and get them to talk about the Illinois election of judges, I just wanted to take a couple minutes to kind of go over the various kinds of judges who affect our lives. In the federal system, there are Article III judges, which are the life appointees appointed by the president, and they are the heart of the federal judiciary. But we also have Article I, the first article, which is the legislative article of the U.S. Constitution, which talks about the Congress's ability to create various kinds of judgeships. And there are all kinds, and primarily the ones we've heard about lately have been the immigration judges, who are an Article I type of judge. Those judges are not elected by the general public. They are either appointed by cabinet level officers or appointees of the president. The Congress has, for some of them, advising consent in the Senate, for others, even advising consent in the House to look at those judges. And they handle bankruptcy, they handle Social Security, maritime issues. There's a variety of things that they deal with. The Illinois Constitution has the separation of powers, but each of the separate powers is an elected power. So the executive, the governor is elected, the General Assembly is elected, and our judiciary is elected. In Illinois, we have three levels of judges. We have the circuit court, which is the trial level. We have the appellate court, where the bulk of the cases go that are appealed. And we have the Supreme Court, which, like the U.S. Supreme Court, limits the issues that it takes so that it can provide guidance to the lower courts on important issues relating to Illinois law. In the circuit court, we have judges who are elected countywide in our circuit or elected from sub-circuits. Initially, it used to be they were elected from the city only or the suburban only portion of the judges, but that has changed to go to the sub-circuits, and we currently have 20 sub-circuits. Most of the people who I think are listening today live in either the 9th sub-circuit or the 10th sub-circuit. And unfortunately, in this election cycle, there are no elections in those sub-circuits. So the judge elections that are going on right now, we have one appellate court vacancy, and that judge in the Democratic primary is unopposed, and there are no Republicans running against her. So basically, if she wins on March 17th, that's Judge Judy Rice. She will be ready to go to the appellate court. In the circuit court, countywide, there are only two contested races. In both of the races, an appointed judge is running against a lawyer who is challenging them. So if the appointed judge loses in March, they'll be out of a job in the first week of December. If they win, they'll get a 6-year term. Circuit judges win 6-year terms. appellate court judges and Supreme Court justices get tenure terms. The subcircuits have changed a lot, and there are a lot of races and other subcircuits going on right now. But the process of election is basically the same. So I put together this panel tonight to kind of deal with the various aspects of what it takes to get elected. How does a candidate for judge get their name on the ballot? What are the role of a judicial ethics in these races? What are the political and professional backgrounds that candidates need, and how do they get to that? What can they say about their position on various legal matters and how they would decide cases? What is it like to be a judicial candidate? And then one of our panelists was an associate judge before he became an appellate court justice. And one of our panelists is a circuit court judge who gets to vote for associate judges. So what it's like to deal with those kind of elections. Our panelists tonight are Matt Delort. Matt is a retired justice of the Illinois Appellate Court. He is someone who, when I first ran for office, he was my election lawyer. He's one of the most knowledgeable lawyers on elections and judicial ethics. He was appointed an associate judge, elected by the circuit court judges, and then ran for the appellate court and won, and has retired now from the appellate court. He goes around the country these days training judges on ethical issues, as well as being an arbitrator and mediator in a variety of different civil cases. Mary Kay Dawson is someone who I met in 1996 in the state's attorney's race, and has been a political operative beginning before that date and going forward, but who developed a specialty of working with candidates for judicial office. It's a unique subset of candidates running for office because judge candidates are not politicians, and they are not really any good at being politicians. I always tell the story that when you watch groups of judges who are running county-wide, they all get in their cars and they drive all over the county. They show up in Evanston, and they don't get to talk usually. They get to wave. Somebody will say they're so-and-so is here, and they stand in the corner and wave, but they've been standing in the corner talking to all the other judge candidates. Then they get in their car and drive 40 miles to another event, do the same thing. And I used to say to judge candidates, how many voters did you finally talk to? Because all they would do is complain about how many miles they put on their car. So Mary Kay takes those kind of people and works with them to figure out how they refine their campaigns, how they get bar ratings, how they get themselves in a position to win. And our final panelist is Judge Steve Bernstein, to many of the Evanston people known as the greatest Fourth Ward alderman Evanston ever had. Steve is now a circuit judge in the circuit court juvenile division, where he rides the circuit. He is our only circuit rider. All throughout the suburbs, every day, he is in a different place working on cases that involve juveniles. But he has been a circuit court judge, and as a circuit court judge, he has voted and had judge candidates come to him for the associate judge issues. So I'm going to start with Matt Delort. Again, if you have questions, please put them in the chat, and we're going to have this be kind of an informal conversation, and then we'll take your questions, and we'll see if at the end of this you have a better appreciation of why it is important to go to the end of the ballot. Unfortunately, that's where the judicial races are, and make sure that you fully vote for all the candidates there, because those people are going to make decisions that are important to your life. Matt?
Thank you very much, Commissioner, and good evening to everybody. You heard a little bit about my background. What I was going to lead with is this. When I was, because I was an election attorney and advised judicial candidates, when I became a judge, one of the first things that happened is my phone rang, and the Illinois Supreme Court said, guess what? You are now going to be the guy who teaches all the new judges every single year about judicial campaign ethics. And I did that pretty much every year for 20 years. And what I'm going to give you in the next 10 minutes or so is a very very compressed version of what I told that class of judges every year, because we were very adamant that they understood the rules and were at least duly warned that if they violated the rules, what bad things would happen besides merely bad publicity. One of the basic premises is this. The Illinois Supreme Court has general supervisory authority over all the courts, the state courts in Illinois. And in that capacity, it can enact rules that govern everything in the judicial process in the Illinois state court system. And what it has done is enact a code of judicial conduct. It is based largely on model rules promulgated by the American Bar Association, and they are very similar to rules that are in place in pretty much every state and DC and the territories. So nothing is particularly unique or unusual about Illinois that can't be easily transferred over to other contexts, other states. So judges have to look to those rules to see, what can I do? What can I not do? What can I say? What am I not allowed to say? And there are some court cases interpreting these rules, not many, but there are a lot of advisory opinions that are available for them to review. And there's also a wonderful treatise that, believe it or not, is written by an Illinois judge, Judge Ray McCoskey, whose book on judges in the community is just, it's like the Oxford English Dictionary of Judicial Ethics. And it is quite a work if you ever happen to get your hands on it. But I want to talk about, maybe just in bullet point format, what this world is about. First of all, it governs not only sitting judges, but a lot of the rules govern lawyers who are running to become a judge. That may seem counterintuitive, but there, of course, there's a reason behind that, is that they are running to hold an office, and if they did improper things during the campaign, that would come to taint their professionalism if they were to, in fact, win their ultimate election. So almost everything really applies to both the sitting judges, whether they're elected already, or they're appointed temporarily, or they're simply a lawyer running for that spot. One of the rules, for instance, is that the judge cannot raise campaign funds more than a certain amount of months before the election and more than a certain amount after the election. So they're not constantly going around to donors raising money. Now, they're not doing that personally. We're going to talk about that in a little while. I would always tell the judges, here's something I want you to walk away with, if nothing else. Okay. You cannot ask your mother to donate to your campaign. All right. A judge or a candidate cannot ask anybody for a campaign contribution. Unlike a member of Congress who can sit on a phone in a phone bank all day long, day after day, and hit people and lobbyists up for money, judges can't do that. So all the fundraising for the judge's campaign has to be done through a committee. Now, that committee might be the judge's spouse. It might be the judge's former law partners. It might be really good buddies of the judge. It usually is. But they're the ones who have to be the announcers, the requesters, the inviters to a fundraiser at, Cheesecake Factory or whatever it might be. The judge is not allowed to do that. And I'll give you one of my very few war stories for the night. When I was running for appellate court, one of the last stops I made was to visit the home of about a 90-year-old lady with whom my mother used to work at Time Magazine back in the 1950s. Good friend of the Delort family forever. And she was picking up some brochures for her kids to pass out at metro stations for my campaign. And she hands me an envelope with a check in it. And I said, I can't take, but what am I going to do? So, I just let it drop in my pocket, and then I took the jacket off and gave the jacket to someone else to open the envelope later on. But these things happen. They happen innocently, but they happen carelessly. And I was running into people on the street when I was campaigning. And your instinct as a judge, as a candidate, is to say, oh, I'm having a fundraiser at Tufano's next week. Make sure you come. I couldn't do that. And it was so hard not to do that. but hopefully I succeeded, and hopefully the judges I taught succeeded in that as well. All right. So everything runs through the committee. When I was running in 2012, it was the understood rule that not only everything I said, but also that the judges were not allowed to know who donated to their campaigns. So there was a wall of no information passing through. So my treasurer got the money. He made sure that it was deposited. He made sure it was recorded. We hired a consultant to file the disclosure reports with the State Board of Elections. All I knew was the balance, and I could direct how it was spent, and I knew how much we could spend because I knew the balance. But I did not know, and I still don't know, who donated to that campaign. All right. That has evolved over the years because now there's a Supreme Court decision from Washington that says a judge must recuse himself or herself if a very, very large contributor appears before them. And inherent in that is the fact that the judge needs to know who the donors are. So that is evolved, as I said. A judge certainly can appear at his or her own fundraiser and see who's appearing, but some people get free tickets too. So it's not necessarily the fact that you showed up means that you paid. The same rule applies to social media. So I could not put on a Facebook page or a LinkedIn page, "Hi, it's Judge Delort. Please come to my fundraiser." No, you can't do that. And judges often have a personal page for their family and Boy Scout stuff. They might have a judicial page for court information. They might have a campaign page, and all three are necessarily separate. If there's a thank you card, there's a difference of opinion out there. My position was always the judge could not personally thank a contributor, but the campaign committee could. And of course, I insisted that my contributors be thanked and receive a written note to that effect, indicating momentous appreciation for their generosity, and noting that I could not personally thank them under my own signature, but the campaign treasurer was thanking them on my behalf. Right. Another thing that is unique to judges is this, and here's the second line I wanted the judges to walk away with. I said, "You cannot sell lemonade at your kid's Little League game." Okay. Everybody went to a school where they sold candy bars to raise money for Little League or for the Girl Scouts. And Boy says you can't sell Girl Scout cookies. No matter how worthy the cause might be, it could be hospitalizing, curing crippled puppies. Okay. You cannot raise money for it. You can't ask anybody for a charitable contribution. And that extends to passing the basket at church. As I mentioned, the Girl Scout cookies, the lemonade stands, Little League. If you want to be involved in your kids' activities, find something else that doesn't involve asking people for money. Because there have been situations where, guess who shows up? It's a lawyer who shows up at the Little League game and says, "Judge, I did not know that little Tommy was in our Little League. And let me write a big check for the Little League team for your son's team, Judge." You don't want that happening. So the judge has to do something else like drive the bus. Okay. That's also something that's counterintuitive. And sometimes it's very hard for people to make that separation. And of course, they get sometimes rather upset about it. I'm going to talk very briefly about the state of the law here, about campaigning. The keywords are announce and commit. All right. A judge can give a biography when he or she is campaigning. I could say, all right, I'm just making this hypothetically. I can say, "I'm running for judge in Cook County. I have been a member of the National Rifle Association for 57 years since I was a Boy Scout and took gun class in grade school. I have a collection of 79,000 guns in my basement and all this ammunition, and I have been on the board of every pro-gun group that ever existed." I can say that. That's biographical information. What I can't say is that if I were to be elected, I would rule in favor of striking down gun restrictions. Boy, is that a thin line. And boy, do candidates dance on it very, very carefully. We see it in various contexts, depending on the part of the country, depending on the type of judicial office. We see it in Illinois, sometimes with the higher level judgeships, with the pro-choice, pro-life divergence. But it's in sometimes when you're campaigning, people will ask the question, "What is your position on X?" All right. And all you really can say is, if a case comes before me, I'm going to rule on the facts and the law as it exists at that time. All right. By the way, here's my NRA card or something like that. It's not probably the best way to elect judges, but it is constrained by freedom of speech. And the most recent case out of Florida, a judge was brought up on charges about it, and the U.S. Supreme Court, by a very narrow margin, stayed on the side of strict ethics. But there was a strong minority saying it's fundamental freedom of speech. The judge should be able to say what the judge wants to say without going over the line and saying, I commit to rule in a certain way. It's a very, use the word again, evolving doctrine. And maybe there'll be someone who's charged with something in another state or here, and there'll be another test case up the flagpole, and we'll see what the U.S. Supreme Court does. So that is, in a nutshell, what the ethics rules governing judges are as of right now. Things evolve, things change. We were always getting questions about Facebook, LinkedIn, what can we say, what can we put on our web pages? And there are judges, perhaps in other states, I think, where things may be a little more loosey-goosey than Illinois, who not only dance on the line, but jump right over into the pool and say, I don't care, I'm going to win this election by hook or by crook, and I have a right to free speech. So it's an interesting area of the law. It is very much First Amendment grounded, and we will see how it changes over the next 5, 10, 15 years. It was an interesting experience for me, certainly, and a discipline for me to constrain myself during my own campaign to make sure I stayed within those rules. One little anecdote I'll finish off with: when I was running, I was a sitting judge in Chancery, and I was hearing mortgage foreclosure cases all the time. Very small group of attorneys in front of me every single day. And I told my campaign folks, I said, I don't want any of those guys invited to my fundraiser. We're going to make sure they are off the list. We don't want them to know about it. And I had my campaign donations vetted by a retired mortgage foreclosure judge who made sure that no check got in that was from one of those attorneys, and none of them did. Because I didn't want literature mailed out to 3 million Cook County residents saying, don't vote for this guy because he takes money from the lawyers who appear before him. Downstate, where there's a smaller bar, it's a little different, but it was the rule I imposed on myself, and I just cited it as an example when I taught judges. So with that, I'm going to turn it back over to Commissioner Suffredin, and I'll stick around for questions.
Thank you, Matt. So now you know how people get prepared to run for office and what are the limitations that are on them ethically in running for office. And at this point, after they've decided they're going to run and had their announcement, the next person that they deal with is a person like Mary Kay Dawson, who, as I said, is really someone who shepherds people through both the political and the professional process of how do you do a campaign, especially in a county of 5.25 million people. Mary Kay?
Well, I want to thank the League and Commissioner Suffredin for inviting me to participate tonight. I'm going to talk fast, as I normally do, and kind of give a very broad base, because within my topic, there's a lot to go over. The only legal requirement to become a judge in Illinois is to be a licensed lawyer with your license in good standing. If you are running, you have to meet the residency requirements for a countywide, anywhere in Cook County, for a judicial subcircuit, in that subcircuit. Critical to the subcircuit is, if you run in a subcircuit and are elected, you have to be prepared to stay there for the 6 years in your term. You cannot leave the subcircuit until after your first countywide retention vote. So a lot of people think, oh, I'll move to a subcircuit, I'll run, and then I'll go back home. No, it doesn't work that way. It's a 6-year commitment. In terms of the difference between associate and circuit court, and whether it's countywide or subcircuit, if you're elected, it's the same authority and power. The gap is closed between the differences of what associate judges used to be able to do. The main thing right now is the presiding judges are from the elected judges, and they control the chief judge and the associate vote, but associate judges in Justice Delort's case, can go to the appellate, they can go to the Supreme Court, and they have the same rights as a judge. The appointments come by the Supreme Court. We have 3 justices serving Cook County, one just brand new to the court, Sanjay Taylor. Each justice has their own theory and appointment. Justice Tice, who just retired, had a committee. Justice Cunningham has a committee, follows a very similar process to Mary Jane Tice, where they put out applications and then their committee reviews them and they interview and then they send recommendations to the justice. Justice Neville tends to just pick from lists, sometimes from the associate short list or judges he knows. He does not have a committee. So there's no rules that govern how that goes or when they have to fill a vacancy. So vacancies can stay open from a retirement that comes right after the election, and it could be filled, but it might stay open the entire 2 years. It's up to the Supreme Court. If you were running and looking at this 10 years ago, the Supreme Court rotated appointments. So we knew whose appointment it was. About 10 years ago, that stopped, and you might see one justice make 4 appointments, another one posts for 6, then one makes 1, and then it scatters. So there's no real pattern that you can point to anymore, but you will still get the question constantly, whose appointment is it? And generally, until they announce it, you don't know whose appointment. The one thing that all methods of becoming a judge, appointment, associate, and elected share is you have to be qualified. And in terms of the election, and even for associate, when the judges vote, what defines qualified and the most qualified is very subjective. And this is the number one thing we face with candidates is how do you convey you're the most qualified candidate? And one of the things we have found is one, an actual judicial appointment running as a judge says to the voters, I'm experienced, I have the qualifications. The bar ratings. We now have, I think it's a total of 14 bars. I think it's 13 with the Alliance and the Chicago Bar Association. They use the same questionnaire, they do the same interview, they have the same investigation, but out of the 14, you might get all good and 1 bad, and you can't explain where that 1 bar came up with. So we want candidates traditionally to get all good because that sends a better message to voters than trying to explain why somebody said something that you're not qualified. For the associate process, we tend to see the people making the short list and selected by the judges almost uniformly for the last decade have had all good bar ratings. The Supremes will appoint with 1 or 2 bad bar ratings, particularly when they have more data and they know the candidate and they are able to disregard and disagree with what the bar may say. So you don't need perfect bar ratings to be appointed. Elections are very varied depending on where you run, different sub-circuits. The bar ratings are very critical. In the north side where you've got the 9th, the 10th, the 12th sub-circuits, bar ratings are important. Countywide, when you get to different parts of the county, they don't care about bars. If they know the person, they can have all bad bars and they'll vote for them. So when you're running countywide, the higher your bar ratings, the better. One of the critical things when running is that you have to balance the conduct ethics that Justice Delort talked about with the state election laws. And sometimes they don't match up. And we tell every candidate, at the end of the day, go with the ethics. You don't want to do anything that puts your law license at risk and defer. And your first hire when you're running for judge should be a very good, experienced election lawyer. And they should have the final say on questions. Many of the consultants are not lawyers, don't have any legal training, so they'll make a judgment. You need an election lawyer to guide you, or you're going to get in trouble. I advise candidates never to get near the gray area. So you might have a canon of ethics here where Illinois says what is appropriate that might disagree with a U.S. Supreme Court case out of Florida. You do not want to be the test case in Illinois because that's going to be the headline. And that can kill a campaign. It can kill a legal career. So don't go in the gray area. Know the lines and stay well on the other side of it. The critical thing when you are running for office is how do you connect with voters? And truthfully, I sometimes use the example, it's kind of like Miss America. You want to win the Miss Congeniality rather than win the title. It's about personality. When you start the process and you think you want to be a judge, there are 2 questions you're going to have to answer on the bar evaluation questionnaires. If you go to be slated by a Democratic Party, you will be asked it. Voters will ask it. And endorsing organizations will ask it, why do you want to be a judge? And you need a nice, solid answer. And as you go through the process, you can nuance it or add and stress different things to different groups, but your core answer has to stay consistent. And surprisingly, we have had candidates who, when asked that, will say, I don't know, it's my time. That is a very bad answer, very bad. If you answer, which we have, which it's been my dream, again, bad answer. If it's your dream, connect it to reality. Why was it your dream? Did you have a mentor in your life who inspired you to follow it? Were you a young lawyer where a great judge on the bench made a big difference to you? Make your dream a reality. Just don't say it's a dream. The two worst answers we have ever heard are, I need a job and being a judge pays more. You know, I don't even know where to start. So never, ever use those. The second question that comes up with endorsements, political voters, and the bar associations is what distinguishes you or what makes you the most qualified to be the judge? When we see judicial candidates, whether it's the Democratic Party slating process or to voter groups or the CFL, very seldom do you have a judicial resume that says, I've had my license suspended 4 times and I'm very incompetent, but I'd like to be a judge. Almost everybody has over 13 years experience. They're qualified. They have some bar ratings. They've done something. So it's hard to distinguish. So that comes down to what helps you with get good bar ratings and certainly gets you endorsements from organizations and connects with voters are what do you do above and beyond your legal career? So if you're going to run for judge and you're going to be applying to bar associations, start early. Don't wait until you're running. Join the various bar associations. They now have asked on their questionnaires, not only are you a member, but when did you become a member? Because they caught on that a lot of candidates joined 2 months before they sent in their questionnaire. So they want to see that you've been active. Don't just join, you want to be on committees. There's a lot of committees through these different bars that are looking for volunteers. Lawyers can also volunteer to be on the evaluation committees for the bars, which are staffed by volunteer lawyers. So you want to do all of this to kind of get a bar foundation going. Then with your legal work, you want to look for what type of pro bono have you done to kind of add to it. If you know you want to run for judge and you've been a real estate lawyer or a family practice lawyer, you might have trouble with the bars who are looking for more court. You have jury, bench trials, that type of litigation experience. So one of the things I advise, and we've seen being very well responded to, is start taking CLEs, continuing legal education, in areas where you might be weak. So all new judges go to traffic. So if you want to be a judge, take some traffic CLEs. If you're not in criminal and you don't do trial work, take some legal, procedural, criminal procedure, that type of CLEs. The bar associations ask outright, as do several of like the Chicago Federation of Labor questionnaire. They want to know, have you had any continuing legal education on diversity and bias issues? So I recommend to everybody, start taking those and take them every year because things change within the fields. You also want to then, most importantly, to connect with voters is what are you doing in the community? What do people who vote for you relate to you the most? So you want to look for some type of community involvement. And that means donations, giving of your time, serving on a board. And there are so many things that connect to voters. So you can join the League of Women Voters. You can join PAWS or the Humane Society. You can join a domestic violence organization. If you're running on certain neighborhoods in Chicago, being active in anti-violence groups. Another one that connects are suicide awareness prevention education programs. And if you don't have the time, you can say, I've been a donor. But you want to start doing something. Previously, a lot of judicial candidates would say, I coached my son or daughter's athletic team. For some reason, in the last 2 election cycles, Injustice Watch, which is a media operation covering the judicial system and candidates, as well as other CFL and other groups, have suddenly said, what is your community involvement? But we don't want you to add about coaching. So for some reason, the powers that be have decided being active in your child's school or with their youth group is no longer a valid community. So we tell people now, keep that in mind. The other thing is politically, if you're going to run in Cook County and you want to be slated by the Democratic Party for a countywide position, it helps to meet a committeeman before you come in. You will be asked in your early interviews, do you have the support of your home or a sponsoring committeeman? And it's amazing how many people come through this process. And when asked if they have support, we have actually had a fair number of candidates say, I really don't know what's a committeeman. So again, it's not too early to start that. If you think you want to run, get involved. We have elections going. We have a primary. We'll have a general. In a year, we'll have the municipal. So if you think you're going to want to run with political support, volunteer now. You can phone bank. You can do petitions. You can write a check. You can attend rallies. You can work election day. But start it now, because that can be a tiebreaker as to whether or not an organization backs you or the other candidate. Because it is, unfortunately, it's a political world. It's a political race. Also, having gotten active at that level with the organizations and politics gives you experience. When you run as a judge, you have to do your petitions. Even if you're slated countywide by the party, you still have to get your own petitions to help the party. So if you've helped other candidates with it, it helps you with the experience. Candidates are constantly changing. People who ran certainly 10 years ago, but even 5 years ago, would have run relying on direct mail, would have directly been, oh, I'm on palm cards, and that's how you won. We've now evolved where the palm cards and the elected endorsements mean a lot less. And most of the campaigns now, the money goes towards digital, social media, and text messaging. 8 years ago, you weren't allowed to use text messages. So I stress to everybody, when you talk to people to get ideas of what you need to run and what to do, keep it in context of when did they run, where did they run, and remember, every election cycle and every race within a cycle is completely different. And it's a lot of hard work. Before anyone runs for judge, they should answer a couple of questions. They should first and foremost acknowledge it's going to be expensive, it's going to be time consuming, and it's going to be stressful. And that stress is not just on you, it is on your family. So these should be decisions made in a broader group about, is this a good time for the family for someone to run? Sometimes people with young children decide they need to be more present for family events and birthdays. Or they have kids about to go to college, and it's like, well, maybe this isn't the year I want to put $50,000 into a campaign because I've got tuition. So these are things you need to have the discussion sooner rather than later, and then start building your foundation. You become a candidate officially about a year out, but you can start building that foundation and doing all of these other things to get going. So I think I'll kind of end there to stay within my time frame.
Thank you, Mary Kay. One of the things that candidates need to remember is that it's a political process, so that the people around these elections are not looking at it like a judge in a courtroom trying to be fair and impartial. They're trying to be biased and partial to what their needs are. And we got the sub-circuit system in Cook County in the late 80s because people felt that there were not enough African Americans on the bench, Hispanics on the bench, women on the bench, or Republicans on the bench. And the initial sub-circuit maps were drawn for those protected classes. And it's funny, the Republicans were a protected class at that point. Now we've added 5 new sub-circuits in the last 2 years, and those maps were drawn and the others redrawn again to try to create political power bases for people from various ethnic groups. Now, the 10th sub-circuit, which is the one that's immediately west of us, was drawn and was identified in Springfield as the Jewish sub-circuit. And it was done because the 9th sub-circuit, ours, hadn't elected a Jewish person since Steve Bernstein and Jeannie Bernstein. But the interesting thing is, last year, with the first elections in that new Jewish sub-circuit, the 2 candidates in the most contested race were a guy named Murphy and a guy named Kelly, who ran against each other. Murphy won. So you can't manipulate these things the way people used to be able to, but they are factors out there, and it caused committeemen and others who are involved in the process to either support or not support people because it was against what they thought were their best interest. That brings me now to my good friend, Steve Bernstein. as a circuit judge, as somebody who's got to run in this environment, you've also run for retention once or twice, right?
Right.
And elected an associate judge. Can you tell us what it's like to be the candidate?
Thank you, Larry. Thank you, League of Women Voters, for inviting me. Larry, for inviting me. My predecessors here have been so complete that I don't have to say anything. Matt, let me just explain that I believe in my heart that my dear departed mother contributed $18 to my campaign fund, but I knew that I couldn't ask her if she had. We're talking about, and I wasn't exactly sure where this was going to go tonight, because when I hear about the election of judges, the question becomes, is it a merit or is it election of merit selection, or is it a political process? And with merit selection, you're always concerned about the merit of the selectors. Who is going to be appointing these people to serve you? And I have no longer any First Amendment rights, so I can't say anything about our current state of government, where I believe things may be skewed. But the reality is, we who are trying to become judges, and if you have to have a job, being a judge is the best job in the world. People stand when you come into the room. They laugh at jokes that aren't funny. You make up your own mind, and until the Justice Delort tells you you're full of beans, everything is fine. You've created it. But the reality is, in order to become a judge, you have to campaign in a partisan, intensely partisan political campaign for an absolutely nonpartisan political job. And you've already heard that in order to begin to run, you have to first do your homework, but then you have to hire a campaign manager, an election lawyer, and if you're going to run countywide, you probably should get a driver, because you don't have enough time to park your car because you're running in and out of different organizations trying to do whatever you have to do. Personality is a big part of it. I was elected from what was the 9th Judicial Sub-Circuit. It's now been changed. It was approximately 400,000 voters. And Larry alluded to the fact that when the legislature, in wisdom, created the sub-circuit system, they put in 15 sub-circuits. And the initial intent, I think Senator Andre Young, was they're trying to get more blacks and more Republicans on the ballots. But the reality is, what they were trying to do, I think, is to bring the electorate closer to the judiciary. And in order to do that, instead of 15 sub-circuits, they should have probably had 75 sub-circuits. Because my sub-circuit went from the lakeside on the east all the way out to Maine Township. And from the border of Wilmette on the north all the way to about 6,000 north in Chicago. There was no way that I could knock on that many doors. So what you have to do is you become a partisan. You have to go to a party, because that's where the bulk of votes are initially situated. And I can give an anecdote. My wife allowed me to use her history. My wife always wanted to be a judge. That was her life's ambition. And so when she decided to run, it was a fairly new 9th Sub-Circuit. There were probably 12 or 15 people running on the Democratic side. There was one Evanstonian running on the Republican side who was lackluster. Subjectively, he was not qualified in our opinion. And we said, hey, this is a non-political job. What about this? Why don't we run as a Republican? Okay, you're going to run as a Republican. And she did, in fact. She became Jeannie. Her license says she was Jeannie R. Cleveland. She ran as Jeannie R. Cleveland Republican. And we had historically voted for Democrats and Republicans. We voted for people, not parties necessarily. We were never affiliated with the Democratic Party, although we probably voted more Democratic than not. But I first became aware of the differentiation when I was trying to get her petition signed. People said, she Republican or Democrat? She's running as a Republican. And people would actually do that. It was a time when the president was not very well regarded. He happened to be a Republican. And we had one person who, it was just a very, very difficult awakening for us. Well, she ran in that election, and she won the Republican primary. Now, okay, man, hey, we run the Republican. We're going. It's a nonpartisan race. We campaigned as much as we could, finding all this difficulty along the way, going to various, the Democratic Party didn't want to see us. The Republicans didn't believe that we were Republicans, which we weren't necessarily, but we were running as a Republican. She won Evanston, and she lost big everywhere else. Her name was Jeannie Cleveland. People would come to me and say, I looked for your wife on the ballot. I didn't see her. Well, her name is Cleveland, not Bernstein. Some years later, we got smart. So she said, okay, now we're going to run as a Democrat, and we're going to, you're going to just, you married me, so you're a Jew by marriage. And she became Jeannie Cleveland Bernstein, because this was theoretically a Jewish sub-circuit, the Ninth Sub-Circuit. In point of fact, when Sandra Otaka won the first race, she wasn't Jewish. But we ran, and now we were able to campaign, and she again had some very, very tough people against whom she ran. A guy named Suffredin, who happened to be the committeeman in Evanston, was interested at the time, and she ran against some very capable people. And invariably, when we came up to people, say, hey, we're running for, wait a minute, you're a Republican. You ran as a Republican the last, well, well, she lost by at one point in time, people would become very irate. You're pretending you're Jewish, and even, people who were good friends, she's not Jewish. Well, no, I was raised in an Orthodox Jewish home, but I didn't ask her to convert because I now know my place in the world and I know my place in God's world. But I was no longer practicing Jewish person, so why would I ask her to convert? So she was not a converted Jew. She wasn't a Jew. We never said she was a Jew. She just happened to be my wife, whose name was Bernstein. She lost that election. We became very schooled in politics. And she said, I think I'm going to get involved. We had become involved in the Democratic Party by that time. She became the committeeman of Evanston Township. And during the course of her committeeman's role, she was meeting and greeting with people who were trying for her graces in the Democratic Party. And these people would come to her and beg and plead and lie and cheat and whatever else they could possibly do to get the favor of the committeeman. At one point in time, she looked at the resumes of people who were coming in to her, and she said, I'm running for judge. The party appointed me to fulfill her last 6 months as a committeeman because I didn't want the job. Other people who wanted the job, they were afraid would get lost in the job, but she notified all the people who had come to her for the anointment, and she said, I apologize to you, and it was nothing that it was a spur-of-the-moment decision, and she became the Democratic candidate for judge in the sub-circuit. This is now her third time. I went to the backdoor meetings, and I was in the presence of people who were talking about, she's not, this is a Jewish section, you can't. And I had the committeeman from New Trier and the committeeman from the 49th Ward on either side of me, holding my arms in my mouth so that I wouldn't open my mouth and say what I had to say, because she'd already, she knew these people. These people knew her and her competence. And she won the election, served faithfully as a judge in the Circuit Court of Cook County for 17 years on the divorce bench. And after 3 years of retirement, she was recently recalled. Again, she was recalled to serve. That our calling has always been that we want to serve community and we want to do what we possibly can. Well, she was so happy on the bench that I never aspired to be a judge. At the time, I was an alderman in Evanston, and I decided, hey, when we met people, oh, hi, this is an alderman. Oh, a judge. Wait a minute. I have an ego, which is now being squashed. But I thought it was a continuation, and to allude to Mary Kay's, we do want to serve our community. We had children. We wanted them to know that you should be active in your community. You have to have a say in things if you're truly involved and you want to become involved and you want to guide your own path. So I became a candidate for judge. I did not hire I guess I did hire a campaign manager who was previously working with Jan Chakowski. He was one of the children who we stayed with us during the campaign. Jan didn't pay very well, so we housed them, and he was a wonderful young man, and he helped me campaign. I chose to run in the sub-circuit because the countywide race would have been futile. It's just too big an area, and there you have to look to other things such as your ethnicity, the statement and equality of your name relative to the numbers of electorate who may bring you votes. But we campaigned very hard. I went from place to place to place. I knocked on doors, not 400,000, but as many as I could. And you had to, you're always currying favor. Well, the reality I had been a criminal defense lawyer for about 25 years. And I pretty much stopped that practice because when I became an alderman in Evanston, which I was for 12 years, I employed the police. So people who would come to my law practice in Evanston, I couldn't take their case because the police officers were my employees. So I stopped doing criminal law, changed the nature of my practice. When I ran, the Chicago Bar Association found me unqualified. And I came to find that one of my opponents had a connected father who previously was very well connected with the Chicago Bar Association. And I was denied their approval because of lack of recent litigation experience. I said, wait a minute, I've done hundreds of juries. I practiced in the courts for 25 years. The law changes every day. You got to keep up anyway. I've been an alderman now for 12 years. I'm making determinations that impact people's lives, which is what a judge is supposed to be. What are you talking about? And we appealed, but it came back. They didn't accept the appeal. Well, fortunately, I was found qualified and well qualified by all the other bar associations. And I won the election, and the opponent who was, he didn't do it. He's a very wonderful guy, but, he didn't know his father was doing this or bringing people into chambers and saying, hey, you got to vote for my kid. Hey, you got to contribute to my kid. Cook County, I came up practicing in Gaylord, and I knew, a lot. I was raised in a very, very, very righteous family. I believed in ethics. I still believe in ethics. My biggest problem as a judge is that I have lost my First Amendment rights, and I have a big mouth. I have a feeling about what is right and wrong with our society. I have 6 grandbabies who are my prides and joy, and I'm scared to death of what's happening in our world. But how long have I been talking?
Not long enough. Keep
All
going.
right, I'll keep walking. I'll keep talking a few minutes. Now, with respect to when you become a circuit court judge, you first start in the traffic court. All baby judges start in traffic court, and you learn to be a judge. And the reality now, I just recently was looking at the Illinois State Bar Association ratings, and they've found not qualified people, lawyers who were, again, not litigating currently, but previously had an extensive litigation, or people who were in jobs where they never were near the courtroom. Well, I think it's really important that you get somebody on the bench that is well-rounded. Somebody, obviously, you have to know the law. That goes without saying. You have to be a lawyer. I would like to think that you're a fair-minded human being who has people in their hearts. And that's the kind of a person I would like to elect as a judge to serve me. Now there's a lot of things going on, but you have to, we created, a gentleman named Peter Kelly and I created an Evanston Bar Association back in the day. It wasn't supposed to be very political. What we wanted to do is, if we were going to do a real estate closing with another guy from Evanston, hey, we want to get together. We want to know who you are before we get to the table. And it was supposed to be a social kind of a club. A couple of the banks in town wanted the business of lawyers, so they actually funded our meetings. We used to meet in the banks that are all gone now, but the State Bank and the First National Bank, we would literally go and they would provide a spread for us. And it was a wonderful, wonderful situation. We got together and everybody talked. We became friends among people who were in the Bar Association. Shortly after maybe 2-3 years into the mission, people say, hey, we need some continuing legal education. Hey, we need it. And suddenly it took on the persona of a real bar association, which wasn't necessarily what we envisioned. So it sort of faltered because we didn't play the game. I became affiliated with the North Suburban Bar Association. I've been on their board probably for 20 years plus. I had occasion to sit on the evaluation of judges, and I saw how difficult it is when somebody comes in. Hey, hi, Judge, how you doing? Judge, no, I'm not a judge. I'm a judicial candidate. Oh, sorry. Yeah, I'm sorry. Well, how do you feel about this? Well, I can't say. Are you being evasive? No, I'm following the canons of ethics. I can't talk about it. I wished I could. I can't. But I also saw, sitting here as a first-timer, that people with axes to grind against judges or lawyers, they had lots to say, and if they were vocal enough, sometimes they could sway the Bar Association rating. Unfortunately, I still see that happening now. It's the Bar Associations have become political with a small p, and that's a difficult situation. It really should. I don't know if there should be partisan races for judges. I don't think so. I don't necessarily think that this came up once when Governor Rauner was the governor, and he proposed, he wanted to select judges. And I said, wait a minute, that may not be exactly what people want to do. But what else can I?
How about associate judges?
Oh, yes. When you are a full circuit, you're a sitting. I'm elected from the subcircuit, the 9th subcircuit. My jurisdiction is statewide. I can theoretically sit in Belleville. Historically, we've had people from downstate come up and visit Skokie during the summertime. Several of them were from Skokie or from the area. They visited and stayed with their families during the summer. They were judges. I can serve anywhere in the state of Illinois, but I am unique to Cook County as a elected judge. My term is 6 years. After 6 years, I have to run for retention. It's a yes or no ballot. Should this person be retained? 60% of the voters have to say yes or I'm out. That is a difficult thing. I remember one time where there was a particular individual with an adopted Irish name who was born as a Polish person who was running for appellate court in the same election as he was running for retention. He lost in the retention and won the appellate, which to me never quite made sense because it wasn't a 60%, it was a +1 vote. As a circuit court judge, I am empowered not only to select the presiding judge, who comes up for selection every 4 years. But I also sit in judgment on people who choose to become associate judges. Those people go before a selected committee. Judge Beach, who's become our recent chief judge, has now prepared a committee, most of whom are presiding judges, and they will make a selection from among however many people come to them to request the slots as associates. They will decide who they can get on the ballot, and then if there's 15, we will then have the ability to vote for the associate candidates. The associate candidates come hat in hand, and they try to reach out to the circuit court judges. The smart ones also go to the associate judges, because judges talk to one another, strangely, and you don't have to necessarily have a vote as a full circuit in order to be qualified to talk about a particular candidate. But every time people would come to me, qualified people, I would say, hey, this is a marathon. It's not a sprint. You're not picked this time. The party hasn't anointed you this time. You run again. Run again. But it's, in my estimation, having been elected to the Circuit Court of Cook County and now retained for two times, I can honestly say that the electorate doesn't know as well as the judges who might be a good judge. And in my estimation, again, it's just my mouth, I think on balance, the associate judges are probably better qualified than the full circuit judges. Now, we have wonderful full circuit judges. We have wonderful associate judges. Historically, associate judges couldn't do felonies of a certain kind. Now they just can't be presiding judges. But it's pretty much the things are blurred now, and they're basically they're wonderful judges both on the circuit, and there are people on the bench that if I given the ability to vote for them again, I would never vote for them. I cannot tell people not to vote for people, because I can't endorse, or I have no rights. The canons of ethics preclude me from endorsing or doing anything other than sending money to a person that I choose to support. What else, Lair?
I think that's enough. Steve, one of the things, and I'd like to get both Matt and Mary Kay in on this. You've talked about the various bar ratings, and Mary Kay talked about 14 bars, and those are not liquor license bars; those are bar associates.
Right.
How have you seen, first of all, the evolution of them? Many of them now are racial or ethnic bars.
Right.
We have Black women lawyers. We have Black men lawyers. We have the Cook County Bar Association, 3 bar associations that deal exclusively with the African American community, and so on and so forth. That's how we get up to the 14. But how has that changed in terms of how evaluations have been done?
Can I address something,
Sure,
Gary?
please.
In the last 5 cycles, we have seen bars becoming more and more. I mean, Judge Bernstein talked about how his own experience with a bar finding him not qualified because they had a personal vested interest. That has always gone on to a certain extent. It has become much more problematic recently. The Cook County Bar historically just gave ratings. They didn't play politics. In the last 3 cycles, we have seen them find almost every Hispanic candidate who comes before them unqualified with having bias. They appeal, and then the Cook County Appellate group overturns it and finds them qualified. We have seen if you are very active in a bar and you have weak legal credentials, you will sail through with fine. But again, what Judge Bernstein pointed out, somebody who's a great litigator but has something a little different in the last 2 years, isn't connected, will be dinged. We see it's kind of an evolution. We have a lot of the bar evaluators now are literally 3 to 5, 6 years out of law school. We have had problems with the last retention class where both the CBA, which historically has had top, evaluators, but they were having trouble finding volunteers. And the Alliance did not understand that housing court eviction court and foreclosure court are three different courts. And if the people doing the evaluation don't know the basics, that's become a
Yeah.
real problem.
Mhm.
Well, with evaluators, the situation that I'm seeing is that you mentioned the younger people who don't have really strong practices yet have the time to devote. It's very time consuming. You have to, if you're going to commit, you have to be there for each and every applicant. You can't just come for one night. You have to listen to them all and make your decision based after you hear all the stories from all these people. It's a very difficult process.
You also have
Matt has something to say.
a number, as you said, you have many, many bar associations. Many of them are sort of based by ethnic identity. And these tend to crop up. There seems to be a new one almost every year. And it's wonderful for those attorneys to, be able to communicate with each other and to share, their background. But the problem is some of these groups are so tiny. These bar associations, they're not hundreds of lawyers, they're not dozens of lawyers, they're a handful of lawyers, and they simply cannot staff their seat at the evaluation table because you're calling on this association, which may be 8 people, of whom maybe 2 or 3 are actually active, to sit for days and days and days and read giant compendia of background material on these candidates. And that's why, as Mary Kay has said several times tonight, there's a backlog. And here we are, early voting has started. We still don't have evaluations from the Chicago Bar Association. We only just got the Illinois state ones today. And it gets worse and worse every year because of the backlog and the lack of volunteers to participate in this process.
So we have one question that I'll read it. It says, voting for judges is very confusing for most voters, in particular those not familiar with the judicial system. The multiple bar association ratings require a lot of work, and bar association panels can reach conflicting results. Do you have any advice on how to prepare to vote for judicial candidates?
Well,
Mary Kay?
Mary Kay?
I would say what we like to look at is if it's a county-wide. I know a lot of people, there are issues. No system is ever perfect. The Democratic Party is not perfect. But they do try to put the time and the effort into finding people with the qualifications, who have some abilities, have a reason to be a judge other than they want to be. So the screening process in the last, maybe 5 years at the party has become much more intense under Senate President Don Harmon chairs the committee. So I think that's a good goal if you're looking for people at the countywide. It's not exclusive. I think, when you get to the bars, you have to look. One of the problems with the bars too is they don't explain their ratings. The ISBA takes the time, that's the Illinois State Bar, it will tell you what they base their rating on. So you can go, you know what, I don't like that criteria or not. I think what you have to do is try to get information from people you respect who might know them. If you know lawyers, you know judges, ask them, do you know anything about this person? Now, Judge Bernstein said, ethically, he can't say, yes, vote for them. But he can say, they're a good judge, they show up for work. That's really the best you can do, is to find someone who knows them that you trust and respect and get their opinion.
Right.
Matt?
And on the same question, I would say, if there are conflicting results, see if there's a candidate in the race who doesn't have conflicting results and they're all good. Okay, if they're all bad, then that's another story. But there's a factor at play that some of these smaller associations, someone may be making a decision all by himself or herself on behalf of the association who has appeared before the judge and lost a big case. And they've got a grudge against the judge, but everybody else thinks the judge is fantastic. But that leaks into the ratings as this little red check next to their name. And I've heard a lot of stories like that because sometimes they'll tell me, I know who it was that dinged me at this bar association. So it's like ranking students in a classroom. I mean, somebody's going to have all A's and somebody's going to have all A's and a couple B's. But if no one's got all A's, then give your vote to the person who's got mostly A's and a couple B's.
There are people who take their time to go through all the bar ratings to compare one to the other, to Google the candidate, to even, look at the, now when I ran, we didn't have websites necessarily like this, but to see what the person is about, you have to become very, very much aware. The reality is, Larry, you tell me what the percentage is now. Historically, about 50% of the voters stopped at the constitutional offices. They never went to do the long list of judges because they didn't know and they weren't going to be bothered. Some of them take time, God bless them, and they become aware. I think if I were to ask people, or if I'm asked, when people ask me what, I say, call lawyers, call your friends that are lawyers, see, who they know that are good judges. Go sit in the courthouse. Except for my court, which is juvenile court, they're all open courts. You can sit and watch a judge. If you have a question, if you're truly intent on choosing wisely, which is very difficult, now this time we only got 2 running, so it's not going to be as difficult. But it's really very intense. It shouldn't be a political process like this. It really should not be. You shouldn't have to become partisans in order to become a judge. It would be nice if the Democrats and Republicans could get together and choose candidates that they both felt were qualified. And then people would vote in a nonpartisan election for judges. But the League of Women Voters should work on that. That's what they're good at.
Yeah, the one of the questions we have is there any chance of judge elections could become nonpartisan? I just looked at the Illinois Constitution, and while it gives the General Assembly the ability to make laws, it also talks about primary elections and general elections. And
Right.
So there are kind of limitations there. Matt is the constitutional expert on this panel. What's your thought of any chance of changing this?
Well, you're right, Larry. The partisan elections are baked into the 1970 Illinois Constitution. And so it would take the General Assembly and the voters to change it. And I don't think there would be let me say it this way, there would be a very negative reaction to that downstate, where almost every judge is Republican. And they'd say, well, this is the Democrats trying to sneak in some people who have nice names or something onto our bench, which is now all Republican, or vice versa, I suppose.
Yeah.
The situation in Cook County is that it's so overwhelmingly Democratic almost everywhere, including even these extra 5 subcircuits. There has not been a Republican elected county-wide judge in Cook County in a contested election since 1966. Okay.
Amazing.
It's a long time ago. There have been a few Republicans elected out of the subcircuits. All those subcircuits have since moved on to electing only Democrats as the suburbs have gone more Democratic. So we really only have one election for judges in Cook County, and that's the primary.
Democratic primary. That's right.
Yeah. A number of years ago, I was with a group. We were trying to get a merit selection amendment to the Illinois Constitution. And we did a forum at Channel 11. And Senator Pate Phillip, who was then the president of the Senate and a Republican from DuPage, was there to debate us on merit selection. And at one point, what he said was, I'll always remember this, he said, maybe for Cook County, merit selection's okay. In DuPage County, we don't need it. Our judges do what they're told. Whoa! but, we had Democrats who opposed merit selection because they wanted to know who was going to make the decision, who would decide. And I think that the question of trying to get nonpartisan elections really is maybe an issue the League of Women Voters should look at. And you always were leaders on the merit selection of judges, and maybe it's time to revisit some of those situations.
Yeah.
The other thing where there's been an amendment proposed periodically that I think the league supported dealt with retention. When Steve was talking about people not going to the bottom of the ballot. Now, in this election, there's so few candidates, it's not bad. But normally, it's when we have the retention ballot. And on the retention ballot, we've had as many as 125 judges running for retention. And it's a very difficult thing to go through. But this retention amendment proposes that there would be panels, ethical panels created around the state. And if a judge got through that, they would not have to run for retention. They would automatically be retained. And only those judges where issues were raised would be put on the ballot for retention. I think we need to look at some of those.
Yeah.
We have another question that just, go ahead, Mary Kay. I'm sorry.
I was just going to say, having done the retention classes for a number of years, it is a real problem because voters don't understand the difference and they're judging the judge's performance, which they don't know. And we have this issue has come up with the Democratic Party, where you have some of the progressives want to, throw judges off, but they aren't lawyers. And Eamon Kelly from Evanston did a phenomenal job chairing that committee because he made a point of any judge that somebody raised an issue of, he investigated by talking to the lawyers in the courtroom. He would hunt them down and find them. He would sit in on numerous times to observe. So he kind of made the party's voice a little bit more reasonable with a lawyer. You have Injustice Watch that goes after retention judges. No one on that paper has any legal background, and they don't understand the difference between an appellate decision that remands versus reverses. So we have a bunch of these problems with retention. So I think the idea of going to the method you thought, Larry, is where we need to move.
Well, it's interesting you mentioned Eamon because I know with a number of judges, he went and sat in their courtroom so he knew what was going on. But Eamon is the son of Peter Kelly, who was the co-founder with Steve of the Evanston Bar Association. I have one last question, and then we'll kind of wrap this up. The question is, are there enough judges? I keep hearing that there are big backlogs of cases. Is this true? And if so, what can be done about it? And maybe it's the reason Jeannie was recalled because they were short on judges. But what's your thought on the volume of cases within the Circuit Court of Cook County and our appellate court?
Let me say this, Larry, if I can start the conversation. This is a public administration problem. Okay. You've got 400 judges in Cook County. At any given moment in history, they are not all full. Some have passed away. Some have retired. There have been no appointments made to fill those spots because the Supreme Court says we're going to wait until the election cycle. 5% of them are on vacation any given week. Okay. We have a very compartmentalized system in Cook County. We've got the divorce judges and the probate judges and the criminal judges, all these different categories. And some divisions are much more current with their work than others. And I'm going to be very bold here, and I'm willing to be shot down by, if there's a criminal court judge on the phone here, there's been a lot of discussion in the public arena about Cook County Jail and people waiting a very long time for their cases to get tried. And maybe we should double the size of 26 in California and have a lot more judges in criminal court there to try these cases so that those who are awaiting trial, who perhaps they used to be not able to afford bail, but now they are held because of various reasons under the Safety Act, they can get a prompt trial and be adjudicated more quickly. And of all the divisions in the court that I saw when I was on the appellate court, I would say the oldest cases came to us from 26th in California, because it was logistically very difficult to get all the police officers to testify on the same day, the witnesses, the expert witnesses, the DNA people, and they just kept getting continued for all those reasons. Larry, I know you were a criminal prosecutor or defense attorney, I forget which one. Maybe you have some thoughts on that. But we have a new chief judge. I think we were in stasis for a long time with Chief Judge Evans, and maybe there can be some very serious attention given to the management of the different divisions to see which ones can use extra judges wisely and usefully, and which ones you've got judges, spending some time that, not having any cases to hear. So enough said.
I think our real backlog is really in the criminal side. And one of the things that people don't understand is that defendants often don't want a speedy trial.
Exactly
The
right.
reason
Very
we
true.
don't have any penitentiaries that are near to Chicago, and persons can get credit for their time in the Cook County Jail against their sentence. And what happens is they stay here, their families can visit them. And then when it's time to plead guilty, they take time served. What happens, Tom Dart tells me that each week he takes about 150 people out to Joliet. They get processed, and then they get put back on a bus to Chicago because they've served their sentences.
Right.
But they served them at the county jail. So there's a lot of different nuances here. I think,
Right.
but I'd like to first end by thanking our three panelists and for each of their perspectives on what it is that it takes to run for office. The one thing I'd like to end with is that when you look at these bar ratings, and it used to be the newspapers would print them and there only were 2 or 3 in the columns. Now when you have 14, it's like looking at an old train schedule, trying to figure out what stop is somebody going to. I think what you've got to do is figure out what are the more credible people who are looking and analyzing this. And as Mary Kay said, Injustice Watch is really one of the few publications, though it's a partisan publication in one regards, it's a not-for-profit. But the Sun-Times has stopped doing endorsements. The Tribune doesn't endorse for judge. So we don't have third parties who look at these things and try and figure out what they are. Maybe that's a role that the League of Women Voters can have in the future, and having voting guides that begin to analyze how these 14 bar associations are looking at things. I'm going to turn this back over to Georgia. And again, I want to thank Judge Bernstein. I want to thank Justice Delort, and I want to thank Mary Kay Dawson for their input and for your questions from the rest of you. Thank you. Georgia?
Well, thank you, judges. Thank you, Commissioner. This has been an enlightening evening. We thank you for your time. And we also thank the many participants and the questions that they've asked. We periodically do educational programs, so look for an issuance from us that has future programming. And in the interim, this concludes today's session. Have a very wonderful evening. And again, thank you to all. Bye-bye.
Thank you.
Thank you very much. Thank you very much. Appreciate your inviting us.
Indeed.